going. My name is Jason Purinton. I'm on the board of directors. I am the forensics section representative to the board and the moderator for today. I have a few quick announcements to make. Also, the session's being recorded as they've all been. If you've got questions, please wait and I'll bring the mic. And I just always remind people, even if you've got a loud voice or something, let us give you the mic so that we get a clear recording for the people who are doing the online bundles. Please be sure to silence your cell phones while you're in the room. Also, be sure to download the conference app. There are a number of features on there, including messaging, viewing the session descriptions, the speaker bios, and some other features. Just want to remind everyone it's a professional conference, and please provide the speakers with the respect they deserve by turning off your ringers, PDAs, and please no side conversations. You'll have to complete the online evaluation to qualify for the continuing education credits. I'll give out the code at the end of the session. With that, I'm going to introduce this session's speaker. We have two speakers today. This is the session for expert final options, Social Security work incentives for future earning capacity. Today's speaker, Michelle McBroom-Weiss. She's a vocational consultant and vocational expert. She has over 30 years of experience. Ms. Weiss has served in leadership roles within IARP and currently serves as the secretary to the board of directors. She speaks nationally regarding vocational rehabilitation and forensic options. Our second speaker today is John Yent. John is currently the executive director and benefits counselor for Recovery to Work Disability Services, a Ticket to Work national employment network based in New Orleans, Louisiana. John has been involved in vocational services for individuals with disabilities since 1986. He has also served as a vocational expert in more than 10,000 Social Security disability hearings since 1997.
Jason, good morning, everybody. Thanks for being here. We appreciate your time. Yes, excellent. All right. So I would like to, first of all, let you know as a disclaimer that between Michelle and I, we must have at least 50 years of experience with working with folks who have disabilities, but also doing some Social Security vocational expert work. You have a lot of experience. We do encourage questions. As you have questions, let us know. Questions are how we learn. There's no such thing as a dumb question. So if you have that, please go ahead and raise your hand and we'll make sure we address those as well. I want to have Michelle get us started here with the learning goals.
Okay, well, we'll get started. John and I did this presentation a few years back and not at IARP, at a different conference. So we've updated it a little bit, but it's a lot of fun to present with John. I always say I'm the straight man and he's the funny one. So if I get a little too dull, he may just jump in and we banter a little back and forth. Can we advance the slide? Our learning goals today are to understand Social Security disability does not mean permanent unemployment. For vocational expert summary of Social Security work incentives. One of the things John does Ticket to Work, I do not, but I wanted to be familiar with it as a forensic expert and also in my job placement cases and other work that I do. I love, when we did the first presentation, I knew some of the work incentives. I learned so much putting the presentation together with John. So I think it'll be very interesting to you guys too. Social Security is a safety net for disability beneficiaries and impact on expert reports and testimony and greater reduction of total disability claims. Next slide. The part where I come in is I don't do Ticket to Work. So my part is I do some job placement assistance, but the majority of my practice are expert reports in one form or another, or doing Social Security disability. So most vocational expert reports, we're asked to do wage loss analysis. And I say that because in your work comp system, you may have some other factors. In Tennessee, where I practice, we have a term called vocational disability. I know we have that in Alabama as well. It's kind of unique to our area. I think Idaho also has vocational disability. So you may be considering other factors other than wage loss, but I did want to say, when we're considering our liability cases or tort claims, we're looking at wage loss analysis. The plaintiff orientation is that the disabled individual can do nothing. The defense is they can do everything. And so we also
No mismatch there at all.
no. So that's kind of what we are dealing with when we get that case. The argument is often between the dueling experts, and I think dueling experts was John's term, but I really like that, trying to persuade the court their analysis is correct. And most reports do not address the option of the disabled individual utilizing vocational options available at the state or federal level. The next slide. Can the individual work? It's a fundamental question in our vocational expert reports. Often the obligation of defense experts is to prove work options. And when I say this, we're not really to prove anything. We're there to give an objective opinion. But the defense attorney may be wanting to see what the options are for the person. And we're going to objectively look at that, whether we get the case as a plaintiff or defense. The analysis relies on the best case scenario of the motivated disabled person and what they might theoretically achieve in job placement. Often no actual rehab services are contemplated or budgeted. In such settlement negotiations with disabled individuals being primed to take money and settle rather than to become rehabilitated. In Tennessee, we have a new program called the Next Steps Program. And I was asked to be part of the committee, the state committee. And what it is in Tennessee, our law changed a little bit for workers' comp. In the past, you could get a pretty big settlement and not go back to work at your employer. Now, if you don't return to work at your employer, and I'm paraphrasing, or you don't make the same wage that you were once making, but you're not totally disabled, you get a very teeny tiny settlement. It might be $10,000, or you get perm total. There is no in between. So now plaintiff attorneys are more willing to consider retraining options. And I've even had defense attorneys now sending me some cases for job placement assistance. So it's been kind of interesting because it's not in the law, but the willingness to try to help that injured worker because they just have this small settlement or their perm total. The Next Steps program for us allows retraining funds for an individual to retrain up to $5,000 a year for up to 4 years. So sometimes that's coming into the reports and there's more receptive, but in the past, no one wanted to consider retraining in reports for my work comp state.
If I could ask a quick survey question in here, how many of our members in the audience today are actually actively engaged in job placement with anyone with disabilities? Okay, and everyone else is doing expert forensic work? Wow, fantastic. So one of the things I would add to what Michelle said was the question of can the disabled person work? Oftentimes we're, as vocational experts, we're doing an analysis of this would be an ideal match. These other elements would be an ideal match and based on what our training has told us. But in my experience also, asking the person what do they want to do is a really important step as well, because asking them what they want to do is addressing the key factor of anybody going to work, motivation. Do you like it? Are you going to go to a particular job because somebody else thought it was a good idea? Or are you going to go to that work because you enjoy it and the professional can help you evaluate those options? So another factor.
And for those of us in here that do liability cases, divorce cases, other types of cases other than work comp, we're often doing those interest tests. We may not get the feedback after that meeting with them as to what they would like to do, but we do kind of have an idea of at least interest if we're considering a training plan or something in there. But oftentimes if the person is on Social Security disability, I don't see where people are addressing, okay, here is the potential for this person. This looks like an interest area. It matches their aptitude, but here are some resources to help them get it paid for. Maria, hold on one second.
John, I have a question for you. In your practice, when you're implementing the Ticket to Work program, when you're meeting with an individual who's receiving Social Security disability, what do you do from a practice perspective if the person is not interested in going back to work?
Great question.
But would they contact you if you're not interested? Because it's an optional program, right?
Exactly. That's a great question, actually. One of the factors that's important to know, I hope I don't block the screen here. One of the great factors about Ticket to Work is we are approached by beneficiaries. When a person is awarded Social Security disability benefits, we have slides coming up about that. They are also at the same time offered Ticket to Work program. So I don't have to worry about people, try to convince people to go to work. I just have to explain to them what's going on with the program. They're already motivated by showing up. And by showing up, by calling, by asking for information, they're already part of that. So the motivation factor is the number one step up for folks going back to work. In terms of meeting with folks, I'm a virtual network, so I don't ever meet in person with anybody. I do all services over the phone or by Zoom or methods such as that. The reason, an important distinction between this and other traditional vocational services is we're not there to do vocational full analysis. We're there to do exploration with that person. And from that exploration comes the direction of which way they would like to pursue vocationally speaking. So, but that's an excellent question. Thank you.
And our last bullet says, addressing availability of programs, the expert puts on notice the individual's own motivation is a substantial factor in the potential to return to work or not. I recently had a report of someone and they described Ticket to Work to the person. I was defense. And so the plaintiff expert report had already been produced and they mentioned it to them. So when I meet with them, they're like, oh, no, I didn't follow up on that. Not that they have to, but they have at least been made aware of it. And so then it becomes a question of what is their motivation to return to work if they didn't follow up on resources. And I'm not doing that in an expert report. I'm doing it more so just to show these resources are here. But I have an attorney who he's in a small town in Tennessee. He always, when I'm on the stand, says, Michelle, isn't there a want to factor? And so it's now become this theory of the want to factor. But is the person going to try? And in Tennessee, one of the things we've had in work comp is the question, has the individual attempted return to work? So if they're wanting perm total disability, there has been a Supreme Court ruling that they have to show that they tried. And so often it's just, I know I can't, but they haven't attempted perhaps to volunteer or just see if they can do something. So there's, that question.
One of the things also in terms of how we do services and Ticket to Work is addressing issues of their vocational identity. Right? Vocational identity is the work you did, you identify as part of your own identity. If you have to ask a person who does nursing work, what do you do? They answer with a statement, I am a nurse. If you ask a person who teaches students, what do you do? I am a teacher. So whatever the person's past vocational activity was, that's their vocational identity. When we use terms like return to work, which is perfectly appropriate in settings involving professional analysis, the idea they have in their head is, you want me to go back to the thing I did before? That's totally unacceptable. I need to think about doing other work. So we're helping them explore their options for that.
Or there's always the thing, I've always been a truck driver, so I can't go back to work. I can't be a truck driver. They don't take it to step 2. I can't tell you, and I don't know what it is about truck driving, but it's always a truck driver who says, I can't return to work. I can't do anything because I can't be a truck driver. Have you noticed that? I don't know what it is.
So awesome.
It's about that.
Everyone are great.
They don't take it to step 2, but they also don't have the skills. We forget that we have the skill set. And so we're always thinking to step two, we're, can they return the same employer, same job, same employer, different job, different employer, we go through the steps. They've never had that experience and they've never had to go through it.
And I start with, what do you want to do? What have you thought about doing? You contacted me, you must have an idea of what you want to do. And so that's where I start with my expert process. I can explore with them their interests. And then from that, I can help guide them towards the steps to reach that as well. We should move on to the next slide.
Sure.
No, this one.
This, no, go back.
I'm
You're
sorry.
right.
Sorry.
The one thing that when I started doing this presentation with John, I had thought about it, but not really formally developed an opinion. But even Social Security determines if someone meets their rules and they meet disability, they're not considering that person is permanently and totally disabled. They meet their rules, they meet that definition. So evidence of that is they have a Ticket to Work program. So they may try, they're not necessarily 100% totally never going to work, but they just meet the Social Security rules for disability.
And folks also, they're considering that the term Social Security is equivalent to retirement. So if they hear Social Security disability, they think, oh, I'm medically retired now because I'm getting Social Security, and it kind of undermines the whole incentive or even thought process. Maybe there's something else I could do. Oh, wait, I'm retired now. Not true. Go ahead.
But anyways, Social Security does have continuing disability reviews. Because of lack of funding, I don't think that happens that often, but it does come up and people will have a hearing because they want to get proof if they medically improved or not. Or in the old days of live Social Security hearings, a judge might say, I'm going to grant you disability, but I'm going to put in my notes or in the decision that this should be reviewed in 3 years. This gives you time to get the medical treatment you need and training or whatever you need to get back on your feet. Now, I don't know that it gets reviewed in 3 years, but that was the plan because they really want to emphasize this is a temporary help for you.
Just to add on to that, one of the elements that Social Security has in their review process is whether medical improvement is expected, whether medical improvement's undetermined, or if it's unlikely, it's not expected. So everyone, for some reason, thinks in their mind, I can't do my truck driving job. Trucks are awesome. I can't do that. I'm done. So even if I think I get better, returning to work to me means I'm going to go back to truck driving, not going to do it. Having options of where they understand there's other things they can do with assistance is a great incentive once they realize it's there. No one's advertising Ticket to Work, not even Social Security.
And out of the people I meet with in litigation files, I always ask, have you heard of the Ticket to Work program if they're on Social Security disability? Supposedly, everyone is mailed information about it, but I would say about 50% of the people I meet with say, yes, I got something in the mail. The other 50% say, I've never heard anything about this. And they certainly don't know about state voc rehab unless they've had a family member that's been through it. So I'm not there to rehab this person, but I will at least mention there's a couple of programs. If you get to a point that you feel that you're able to work, I just want you to know the resources are there, and that will be in my report. So they can always go back and reference it if it's something they want to pursue. But I don't take it, it's just a couple of sentences. I don't go into great detail because that's not why I'm there. But I do at least want them to know the programs are there. We've got a question.
Hello.
You have to hold it really close.
Hello. Can you guys hear me? Okay.
Mhm.
Coming from the public sector, we did a lot of work with Social Security. We had a separate entity in the state of Arkansas that actually promoted work incentive programs under the pre-employment transitions portion.
Right.
And so I actually have a very strange case. I have an individual who was injured at the age of 16 or 17 while he was in high school. However, he was a SPED student, so he qualified for Social Security as a student or as a minor. But the redetermination factor, he wasn't going to be eligible for Social Security as an adult under that particular diagnosis. And so we did a lot of work incentive with Section 301. I don't know if anybody has ever heard of it, but he actually got a vocational plan while he was in high school. And through the continuation of his vocational training, he still received his Social Security income. And so he was injured in the middle of that. So now they're trying to determine if he's permanently disabled with a TBI. So it's currently in litigation right now. His parents are more so, they're the caretaker. He's now 20 or 21 years old. And so now they're trying to just go with the settlement and deem him permanently disabled. However, he has not only completed a vocational training program, but he's also had supported employment services as well through a service provider. And so now he wants to work, but his parents are more so like, no, you have a TBI, you can't work. So that's kind of the argument that's happening right now with that particular case.
Sure. And that's always been my problem when I have a case that I think may be eligible, and that yours is more severe, but may be eligible for voc rehab. Maybe they're on Social Security disability, they're going to qualify for voc rehab or ticket to work. Is it secondary gain? But it's people encouraging them, whether it's their attorney. I had a case years ago. This individual, I was working in Alabama. He was a burn case. About 80% of his body was burned. He had been a millwright. He was not going to be able to regulate his body temperature, so he could not go back and work in factories. Tested him, not mandatory voc rehab state, but the adjuster saw that the case manager working the case said, let's try to get him early. Can you considering retraining? So we were doing all this. Very, very motivated, as many people do as they go through an injury. Never had an interest in working in the medical field, but having gone through all of the physical therapy and everything that he really had an interest in that. And we narrowed it down to 3 job goals. If you don't know me, I'm not a very high pressure person, but his attorney said I was just pressuring him and all of this stuff because we were able to work together for a little while. But we got to the 3 goals, and we're having to narrow it down to what do you want to do? And the insurance company was going to pay to help him retrain. He was still doing some recovery. Well, at that point, they said, we have your recommendations, so we'll just, let you back out. Fast forward 2 years later, most motivated guy ever. His wife was a homemaker. He was very dedicated that he was going to work and she was still going to be able to do her job. Fast forward. At trial, he was the most disabled person you've ever met. Had gotten into the disability mindset because his attorney had continually reinforced, you were disabled. It was not the same man I met with 2 years before. So it's interesting in forensics because we're a neutral party, but yet our training is to help people meet their potential. And that's the struggle he's going through, because the parents see probably he's having supported employment. Is he really going to be able to do competitive employment? They're scared if we don't get this money now and he's unsuccessful, it's probably a fear factor for them.
Most definitely. And the expectation, that was an excellent point you were making as well. The input that folks have from their family members, from parents or loved ones or neighbors, or attorneys, especially attorneys, I think, is that don't mess this up. This is your moment. Don't mess it up. If you don't do this right now, things are all downhill. Well, that message can get ingrained. And the real overall picture that we're looking at for working with individuals is, what can they do once the case settles? Can you live on this for the rest of your life? Maybe not. Also, do you want to stay at a level of income that's really determined by other people? So the individual's own opinion is discounted. They're counseled not by us, but they're counseled by other very important individuals in their orbit. Don't do it. Don't do it. Don't even think about it. It's not happening. So it's a lot to overcome.
The parent or the spouse aren't voc rehab professionals. So they're just afraid and they don't know the resources or the accommodations that can be made. So our expert reports are really important if we're giving ideas. The person may not act on it then, but it's in writing. And they know there's an agency that can help me after this case settles. You know, and there was one of these bullets, I think it was on the slide, but private personal injury and workers' comp litigation often do not address the question of medical improvement and long-term effect on vocational earnings capacity. In Tennessee, there is a provision under the work comp law. So if someone receives perm total, that the adjuster can, or the insurance company can go back and reopen and look at it later to confirm they are still permanently and totally disabled. But that tort claim, they're never going to go back on that. But it's just nice to have some information because of the placeability of this person and the resources that are available.
Indeed. If we go to the next slide, please. Oh, I'm sorry. One moment.
I had a case, it was the opposite. I had a young lady, PTSD, bipolar, mental health issues. Lovely woman, lovely young girl. She did want to work, but she felt she wasn't ready to work, and her counselor said she wasn't ready to work. But her parents were pushing her to go back to work. And it was really causing a lot of strife. You know, she was like, I don't want to be kicked out of my house, you know. And I had to sit down with the parents and say, look, it is not a bad idea. It's not a bad thing that she files for Social Security. She doesn't have to take it forever. She could have it while she's getting her treatment, let her get better, and then come back to me. So we avoid this revolving door where she comes back every month because she lost her job.
Well, and you could also tell them about Ticket to Work and other help for her once she's on Social Security.
I think now we're ready for slide 6. Jason, thank you. Oh, I'm sorry. I'm sorry.
So on bullet point number 2, you talk about,
Did we
oh, I'm
change
sorry.
the slide?
Oh, you changed the slide on me.
Go back.
So when they're doing the continuing disability reviews, it says that they're questioning if they've made medical improvements such that they could return to substantial gainful employment. Are they at all looking at any retraining that may have happened in the interim, or are they just looking at the medical and how that impacts the person?
Thank you. Great question. They're primarily looking at the medical aspects of it. If it's a more medical case, if it's more of a mental health case, they're looking at participation in treatment. But they're also going to assess the individual's responses on forms that they're updating what their progress has been since their last medical review or their hearing, as the case may be. But the bottom line is, with continuing disability reviews, especially with mental health, because a person who's mentally unhealthy doesn't necessarily look disabled, do they? Right. So when they're looking at the person, well, you seem fine, you're standing up, you can walk and talk and lift things up. Many times the mental health aspects, and even in the course of doing Social Security hearings, it can be very cloudy what the person's actual limitations are. Plus, in general, in the world, not necessarily when rehab people, there's the expectation, well, if you just paid attention, if you just stopped doing the negative things, you'd be a better person and you wouldn't be so disabled and anxious and fretful. So these reviews are very important, but they can also end the person's disability options.
Another thing we didn't mention as we started, which I think is kind of important for people to know John's background. He's been a vocational expert for many, many, many years, but he had in the middle break where he was a Social Security rep. So he was representing individuals for Social Security. And then he came back to us as a vocational expert and also his Ticket to Work network. So he has a really great perspective because he's been in that representative role.
Okay. Thank you.
Do you want to get started?
So we're talking here about changing expectations about future work. Now, for those of y'all who are doing the forensic reports, providing forensic testimony, you know who hired you. You're going to do your best work, whatever your professional opinion is. You're not swayed by one side or the other. You're out seeking facts, and the facts lead where they lead, right? But in the course of any work that is going to happen potentially afterwards, one thing to consider for those reports is understanding things may change. Things may get better. They could deteriorate, but they could stabilize. One can get adjusted to their current level of functioning. With pain management, things might improve. With other treatments, things may improve. With other surgeries, things may improve. So one thing that's very valuable for the individual you're assessing is having them understand that things can be different, but it's a wait and see situation. So having this idea that services are going to be this moment for your litigation and that's it isn't actually accurate when one has the awareness of, oh, well, I have this option of professional services to return to work or some kind of work. That's an important consideration as well.
In one example, this is an active case. I won't say very much, except I have this job placement case. And it's a workers' compensation case, and the person has PTSD. The psychiatrist has placed her at MMI last week, and is allowing her to work 12 hours a week, but also puts in the note that that's going to change. So in considering that, of course, I'm probably going to be writing I'm not doing the expert opinion. I gave them the choice. I can be your job placement person, or I can be your expert. But whoever is doing that and they're trying to settle this case is going to need to know in the future, how are we projecting or expecting her to improve? So that moment in time, and particularly psych claims to me, they're evolving. She's still going to continue with treatment, but the doctor has been very proactive, suggested voc rehab, wanted her to get back to work. She has gotten a job. It is 12 hours a week. We're hoping she'll be able to increase her hours. So it can change in the future.
Yeah, and as well, what you may find starts to happen for those of you doing the forensic testimony is you may have, let's say you're representing on the plaintiff side, you may have a defense attorney who becomes aware of these other options. If it's anticipated, for example, that the individual would likely be eligible for Social Security disability, don't be surprised if you have a defense expert who brings up that in your questioning. With the client, with the vocational expert, have you even mentioned this possibility to the individual? Have you considered, Mr. or Miss disabled person, have you considered, did you know that these options exist? And so it gets to a motivational question as well.
The other thing is you may be considering accommodations. You may have a life care planner involved or working with them on accommodations for work. You may be considering what training would cost, and that may be part of your plan, and that may be part of your report. This is what I'm recommending here. Usually I'll give 3 options or so, not giving one specific because I don't get to work with the person long term to figure out what their plan is. Here's some example retraining. We can't guarantee that state voc rehab is going to pay for retraining, but you can put it's an option in there, and if they're approved, this may be provided for free, but we don't know. So I always give the price of what it will cost. The job placement assistance, I also say if they have a private vocational rehabilitation counselor in our area, this is the hourly rate. I would estimate, because I've done this forever, this many of hours for assistance, but also state voc rehab is available, or if they're already on Social Security disability, the Ticket to Work program. So there are some free options available as well.
John, what you just said about the scenario of the plaintiff, as a plaintiff vocational expert, you might have a defense attorney not knowing or knowing about options, and then that person might be asked about that on cross. I have seen many, many, many vocational expert opinions, too many, I think, quite frankly, where someone who is receiving Social Security disability, a plaintiff expert comes in and says there's an expectation of permanent and total disability, but so that because they're receiving Social Security, they can never work again, even if you have medical opinions to the contrary. I personally think that's vocational malpractice. I mean, I think it's very irresponsible. I think you need to take in multiple scenarios of, medical opinions about, providing scenarios and what those associated occupations can be. But, this room should be filled, because I think that's an excellent point, because we are impacting people's lives, even if you're in a litigation role. And I sometimes don't think that, some of my colleagues maybe take that seriously.
Well, and the other thing, I think the best point John made to me is if Social Security thought someone was permanently totally disabled because they're on Social Security disability, they would not have developed the Ticket to Work program.
Well, and also as mentioned earlier, there's the three categories: medical improvement expected, we're not sure, or it's not expected. In any of those scenarios, Social Security has no permanent disability, we're never going to look at your case again, a policy. It's not their policy. You are disabled from work that you did, other factors like your age, education, your physical restrictions, those all come into play. But I've seen too many people, I think between the two of us, we've seen too many people who have a scenario where they're 60 years old and they had, all kinds of back surgeries, and they turn in their disability review. Well, I'm mowing the lawn, I'm riding a bike, and I'm walking down my street for exercise. The Social Security analyst who's looking at that says, well, they can be something, they can do something. They'll have their in-house medical evaluator look at those restrictions and think, well, they could certainly do this, that, or something else, especially depending on their background. If they had any kind of semi-skilled or higher background, they may not keep it even then. So good point though. Excellent.
And if you've ever been in a presentation with me, I hate to read slides. So I know that y'all are reading them as we're talking, but I think that we have covered, really have covered the
Yeah.
slide.
Excellent.
Of course, there's a difference in private practice perspective and Social Security perspective. Again, Social Security may deem you disabled, and that doesn't necessarily mean, and it always comes up. I had the most angry individual I met with recently. He was very upset. He said, everybody I meet with, because he'd been sent out for IMEs and that sort of thing, thinks I'm a liar. And he was just very upset. And Social Security is deeming me disabled, and I'm disabled. Well, and even he said, though, my attorneys tried to tell me there are different rules and whatever. And we made it through. I was eventually able to, let him vent, get through the process, tell him I was a neutral evaluator. I wanted to talk to him to get the rest of the story, and we move forward. But it is very different in private practice perspective. It's the inability to engage in previous work, difficulty adjusting to new work, lack of relevant training or experience, permanent barriers to reemployment. Social Security, I'm going to let John handle.
Well, Social Security, of course, their definition is, are you disabled right now at the time of evaluation or hearing? But that, again, as we've discussed, the categories to address whether that's going to continue or not. And then also once the evaluation, let's say they had severe orthopedic surgeries and they were considered medical improvement expected, that might be 2 years, might be 1 year, might be 3, but it's going to be relatively soon. So as far as when person becomes disabled and how long they stay disabled, that's an ongoing snapshot in time. In terms of Social Security's perspective on disability, there's no such thing as disability that's permanent. Also, individuals are encouraged to work. The minute they get eligible for cash benefits is the minute they're mailed Ticket to Work eligibility. And some people hear ticket, I don't know, certain of us from a certain generation think, Willy Wonka, something's coming in the mail like that. Whereas no certificate that comes in the mail, I kind of wish they would, because maybe they think, oh, I'm a winner. Oh, we need to follow up on this.
But it's always interesting. I think we get so much junk mail, but like I said, my 50% say I never received anything.
Lots of people don't open correspondence from Social Security. It's like opening something from IRS. No, you need a cocktail first. But also, and this is also a very key and important aspect. I wish Social Security would advertise this more. When a person's eligible for Ticket to Work services, they don't have a really good explanation in the letter what that means. If you go to a field office for Social Security, half the time the field office agents don't know what you're talking about. If you ask a whole bunch of vocational experts, no one's wrong. If you ask a whole bunch of vocational experts, well, what are the work incentives? They're not necessarily going to know or have this awareness. You all will, because you're sharp. This is a very important factor, and most particularly, as Michelle mentioned, State Folk Rehab is an excellent resource for those who qualify. Of course, there's always order of selection issues, and we have that issue in your states. Okay. So you may have a person who has a moment in time where I'm motivated. Okay, I'm going to look at something. In order of selection, they may not be seen for a year and a half or 2 years, things like that.
And John, I think we go till 12, correct?
Yes.
And so we're on slide 8 and we've got 45 minutes. So I just want to give us a check. So we may breeze through a few of these definitions that are coming up next to where we can get to the guts, because I think the work incentives are amazing. How many of them there are. If you don't know where it is, and we'll have a slide in a minute, it's at the Red Book on Social Security. It's a 60-page book of work incentives. So. Okay. So this is Social Security's definition of disability. And is everyone familiar with it? Okay, so I'm going to just skip this slide because I'm afraid we won't get to the guts. Everyone know the minimum disability criteria. You're off work for 12 months. That's the main thing, or expected to be off work for at least 12 months. The impairments are severe. You might meet a listing. So for those that don't do Social Security, there's a listing of disabilities. And if you meet certain criteria under it, you automatically get disability, whether you could work or not. And then step 5, impairments that perform any work in the economy. The next one.
So there's 2 types of disability benefits. If you aren't already aware of this, there's Title II. That's for folks who had a work history that was fairly recent. Title 16 disability are those who may have had a work history, but it's remote. It ended more than 5 years before the disability began. If you can advance. So these are some of the eligibility parties there. Folks can be eligible on their own work record. You can be a spouse of someone who has a disability and get benefits, or a child of a disabled or deceased worker. Disability of a child which their disability continues into adulthood, as well as widows or widowers. And that involves age 60 or over. So there's different categories for being found disabled under Social Security's rules.
And the next one, I won't read it to you guys, but I think this bullet point is particularly interesting as I go over this. Not be a fugitive felon. So that's one of the criteria.
Yeah. You can't be incarcerated either.
Now, what I was going to say, I don't want to read this. I think most people are aware of it, and John can help me gauge, but I think we'll just go on and move to the work incentives more so. Sure.
Never mind.
Okay. Do you want to briefly? Well, I guess we could briefly go over it.
Well,
You have to be a citizen.
yeah, I mean, basically for Title 16 disability benefits, your disability benefit itself is going to start sooner. There's no such thing as back pay. If you're familiar with Title II benefits, from your period of disability beginning, after a 5-month wait period, you can accrue disability benefits, which may not be paid until you get to a hearing or some other element happens. And you might get a lump sum of, $30,000, $50,000, $100,000. And guess where that goes if a person hasn't worked in so long?
Bills.
But bills. Everyone they borrowed money from, they want it reimbursed.
And the other thing interesting is you can't have, I guess it's still, I think it's still $2,000 or less as far as resources. So
Yes, that still remains current. Okay, so for Title II beneficiaries, this is the best way to be disabled. Plan ahead. Everyone here has a work history, so that's good. One of the most important thing about work incentives for Title II beneficiaries, you have the whole in the Cadillac service. You have benefit payments now. You have Ticket to Work offered to you now. You have disability review protection for up to 5 years. You're also going to get Medicare coverage within 2 years of the date you're eligible for cash payments. And those are incredibly important. And you may think, why is there to wait for health insurance benefits? You get Medicaid, but not Medicare. And frankly, that's always a problem to me. I write my congressman routinely in my 7 shirt, so you might want to consider, how does that make sense?
and I think the disability review protection is really important to know about because so many people I meet with, a lot of times it's a long-term disability case or something else. But even in forensic cases, they'll say, well, I don't want to attempt to try because, it took so long to get disability and I don't want to lose it and all of this. But when you tell them you could, you are eligible for review, but if you're attempting return to work, your reviews cease.
Only within Ticket to Work does that disability review get suspended. You're exempt from that review for 5 years, but only if you're in Ticket to Work. It's a very important concept. So when people are thinking, I don't know, should I try? Should I not try? I don't want to mess up my benefits. It's a nice thing to explain to them. Oh, by the way, you're protected from these disability reviews for up to 5 years if you're participating in this program. So that turns out to be a very powerful incentive.
Okay.
Not only disabled people who are in poverty, right? So what's considered poverty income level for 2022? You can Google it if you want to, but we time limited, so we're going to go ahead and go forward with it. What is poverty? Well, in the United States, as of 2022, a family size of 1, poverty level income is $1,133 in mostly 48 states. Alaska and Hawaii, it's different. It's a little bit more expensive. The idea is, if you look at these numbers, think about wherever you live. Could you exist on $1,133 a month? That's what a lot of people are existing at. And the larger your family size, it's more and more difficult to understand getting qualified for that. To the next one.
And in forensic cases, I hear attorneys say all the time, well, someone just wants to get disability. They just want to be on disability. Now, maybe they're going to get a settlement because they have a different type of disability case. But when you educate them, they're not making very much. And they're probably having a very difficult time if this is all they have right now.
And I can't tell you how many times people have contacted me for Ticket to Work when their settlement money ran out. They had $500,000. It was gone in 2.5 years.
Well, and also because while their case is going on, if it's a liability case and it's not workers' comp and they don't have ongoing benefits and they're not working, they really have accrued a lot of bills. And it's easy for that settlement to go away. It looks like a big amount until they get it and they pay off their bills and realize. And then if on top of that, they're going to try to retrain or spend money, that can go away very quickly.
Exactly. So the goal for Social Security's work incentives is obviously to encourage returning to work. It's not strictly for a reduced benefit payment situation to help secure the Social Security Trust Fund. Anybody wrote with their congressman about the Social Security Trust Fund? Think about it. They're always waiting the trust fund to go pay off other financial or more often political priorities, but something to be aware of as part of the rehab community. But really the goal, in addition to being independent from those benefits, the cash benefits, it's really to reduce the poverty cycle, because people who stay in poverty, guess what? They can't buy things. They can't buy things in the US economy. What happens to the US economy? Anything good? Not so good. So,
And when I had looked at that slide, I had thought about the Social Security judges that say it becomes a culture. Who in your family, your immediate family, I always say mother, brother, is on Social Security disability. It's always amazing to me. Well, my sister, well, what's wrong with your sister? Well, she has a back problem. Well, what's wrong with your mother? She has a mental disability. But it ends up the majority of their family is on disability. And so they don't know the resources out there to help them, and their automatic go-to, because they don't know people who've gone through voc rehab or Ticket to Work, but they know people who have disability. So it's just kind of interesting. So you want to change that cycle as well.
and D, if we go to the next slide. So a disabled worker, this is the average SSDI payment per month, $1,362. Try and imagine yourself living on $1,362 for a moment. What would that be like? If you have a spouse of a disabled person, that's an additional $377. If you have a child, you get $429 for the first 2 kids.
I was going to say it's limited by children. How many children?
Exactly. Go to the next slide. So cash benefits, the current average cash benefit rate we've just shown. Social Security's eligibility program for getting those cash benefits depends on the quarters of coverage. As you know, when you pay your taxes, comes out of your paycheck, FICA, et cetera. Those are elements that are the cash benefits accruing for you. So the amount of monthly benefit is a calculation. It's very important to understand what your registered quarters are. If you're unclear, you can go to My Social Security on SSA.gov, create your own account, and you can determine yourself if they count every month.
Just to want to clarify, but is that 429 per child for the first 2 children? And then is all of that money, then I know Medicare comes out of that to some degree, right? No? Or is it taxed?
So, good question. Good question. Thank you. Medicare coverage is only extended to the disabled individual, not to the family members. And as far as Medicare payments go, Medicare Part A for disabled individuals is free. Medicare Part B is subject to the Medicare premium of 170. I think that's on a coming slide here. But there is a possibility of getting assistance paying for that premium, or it could be premium free, depending on the circumstances.
Okay. And is it taxed? John,
I believe so.
I think it, no, it's not.
SSDI, yeah, not.
The two.
That's right. That's right. Thank you.
Oh, no, I know. I appreciate that. I'm sorry
good.
about that. And just for our timekeeping, we have 35 minutes and we're halfway through our slides.
get-
So I'm going to make him.
We're gonna move really fast. And fasten your seatbelts, okay? We have a lot to do here. All right, so let's look at Title 16 benefits. As of 2022, $841 a month. Now, was it hard to live on $1,134 a month? Is it any easier to live on $841 a month? Oh, it gets worse. So if you're a disabled couple, yes, you have $1,261 as a disabled couple. If you're a single disabled individual and you happen to be living with family members, Social Security says, well, we're helping to support you. So part of what your needs are and your expenses are deemed from your parents. So, or whomever you're living with. And so they'll reduce your 841 to 555. Which is your favorite overpass to live underneath, right? That's where it gets. So the financial incentives are real and they're major. And this is one of the great things about understanding you have hope. There's other things you can look at because settlements run out. So how long cash benefits last? Well, in Ticket to Work, well, for Title II beneficiaries, it goes like this. If you have a disability review, you're not in Ticket to Work, and the disability review comes back, hey, you've done great. Congratulations. Things are looking up for you. You're no longer disabled. That's a termination. Then you have to fight it to get back on the program. If you're in Ticket to Work, you're exempt from those reviews. Keep smiling, gets better. Now, when you are, for example, in Ticket to Work, they're only looking at earnings after your trial work period ends. Has anyone heard of a trial work period in Social Security? How long does it last?
9 months.
9 months plus 3 extra bonus months if you make it to month 9. That's nice. So while you're receiving, let's see, we have an example coming up here. Actually, we can go forward a little bit. Okay, well, we'll back up a few. We can stop one more, but let's stop there. So the trial work month is when you have earnings of $980 in a month. That's counted as one of your trial work months. Any month that you're in SSDI and you've earned at least $980 gross, not net, gross, then that's counted as a trial work month. Now, some people, maybe you've heard of this, some people take advice from their parents, Uncle Charlie, Aunt Sue Ellen, the neighbor, but it will all tell them, oh no, you're disabled. Well, you can work a little bit, but you have to make sure you don't earn more than $1,000 a month. Or sometimes they think it's $1,100 a month or $1,200 a month. Uncle Charlie doesn't know. Okay, he doesn't know. Let's not rely on Uncle Charlie. Okay, he's taking lots of Norco. We don't want to listen to that. All right. What's happened is people are taking information from people they trust, and they think, well, it's got to, they wouldn't steer me wrong, would they? Bad news. If Uncle Charlie says don't earn more than $1,000 a month, and you earn $1,000 a month thinking you're slick, did you use a trial work month? Yes. Bad news. You can burn up all of your trial work months without even knowing that that's a thing for you by listening to other folks who have great intentions and they don't know.
And the interesting thing is they don't have to be consecutive. So you could attempt a
Right.
job for a couple of months, decide you can't do it, and later go back and attempt again. You have the 9 months.
Exactly. And Social Security only looks at a 5-year window. So that's important. Now with Title 16 SSI, you're no longer disabled when your earnings offset what your benefit amount is. So the good news is for Title II, it's an all or nothing benefit. You get it, you get it, you get it until you're earning over SGA and your trial work period is finished. Then they'll look at the SGA test. Can you earn $1,350 a month or not? If you are, your cash benefits will suspend for Title II. They can come back up again to your full benefit rate if your earnings drop below SGA. More on that in a minute.
John, Laura had a question.
I'm sorry.
Are you-
So,
Oh, okay.
so for Title 16, it happens faster. There's no trial work period for Title 16. As soon as you start earning money, they're going to take an offset. Now, do they do it right away? Oh, no, they don't. I wish they would, but they don't. They will only do the calculation when there's either a disability review or something trigger the work activity report. And the bad news is people can get into overpayment situations where they can determine, oh, you were good news, you were working, congratulations. And the amount you made for that 2-month period offsets you. You remain, when the benefits get switched off at Title 16, they stay switched off until you have new information that switches them back on. The important part to understand for Title 16 is you can have more money in your pocket when you're in Ticket to Work by understanding how that calculation happens. And so you're preparing yourself for how soon, and this is where the benefits counseling comes in. How soon does it actually affect your cash benefits? When will that be determined? They're usually not going to do a disability review, a work activity review unless we trigger it, but we make sure that the earnings is going to keep them in good standing. And by that, I mean, we're going to report it, but we're urging them, we're encouraging them to increase their earnings so that when that may happen, they're going to be financially prepared for it.
Wait. Should we record you? Sorry.
Irene. So is the individual required to report their income for both Title II and Title 16?
Yes.
Yes, any income should be reported. Let's go to the next slide. We mentioned earlier that Medicare A is free. Medicare Part B, the current premium is $170 a month. If you're already on limited earnings, it could be premium free or low premium. Depends on your eligibility. The eligibility is a function of where you stand on the federal poverty guidelines based on your family size. Go to the next one. Medicaid is Title 16 benefit, or if you're Title II and you haven't reached your 2 years from cash benefits, you can get Medicaid for that. Some states have no waiting period for Medicaid, and it's automatic when you apply for SSI. These are the states where it's automatic. Some states require an application for Medicaid, even if Social Security is awarded you SSI. So if you're lucky enough to live in Alaska, Idaho, Kansas, Nebraska, Nevada, Oregon, or Utah, don't wait, apply for your Medicaid, because otherwise it will not happen. Some states require an application with special criteria as well. So it's very important to know what the benefits are in your state. And good news, you don't personally have to know what those are. Has everyone heard of WIPA programs? WIPA programs, the Work Incentive Planning and Assistance Programs, they do benefits counseling. It's free, it's no cost. Whether they're working or not, they need to understand what those work incentives are. Let's do the next slide.
No.
I was under the impression that California had something other than Medicaid. They call it CalAid or Does anybody?
I'm not aware.
Again, certain states offer more benefits. It's a great question. Certain states offer more benefits based on their own feeling about how they take care of their state residents. Think about that. California does have extra benefits for those folks who are applying. So that's an important point. Thank you. Go to the next one. Continuation of Medicare. A lot of people, when they're considering return to work, they think, I'm not going to return to work. I can't afford health insurance. Good news, Title II, it continues for a long time. Could be up to 93 months. Let's do the next one. So the trial work period, we touched on that earlier. Basically, it allows the individual to test their ability to work. That's why it's a trial period. We're trying. We're trying. We don't know. It also gives a person the security of knowing that they're going to gradually try working. It's not I'm dropped in the deep end of the pool. You're trying to work. You have professionals with your employment network, hopefully, or whatever other rehab source you have that help you get there. The earnings you can have in the trial work period are unlimited. And you have Uncle Charlie with his Norco, and he's shaking his head. No, you can do it. It's not going to work. You have to really make sure your clients understand that in the trial work period, you're not aiming to earn $1,000. You're aiming to improve yourself to your maximum because you keep it all. Okay. Nothing happens to your Title II benefits while you're in trial work. So that's a giant bonus. That's huge. And most folks have no information about that other than Uncle Charlie.
And how many people knew that after that 9 months, you had the extra 3 months? Yeah, so it's
bonus.
right.
Okay, so you also have So there's the disability onset, all right? Then person, you know, they're medically recovering to whatever extent. They start employment network stuff. They will start their trial work period when they begin earning $980 a month. Even when they finish their trial work period, even when they finish their 3 bonus months, that's when Social Security is going to look to their earnings. Is it over SGA or not over SGA? Well, one of the great things that people don't even think about is they have an extended period of eligibility for those cash benefits. So cash benefits, your case isn't terminated. You are no, say that a different way.
From Louisiana.
You're eligible. You ain't gotta worry about it now. The bonus is, when your cash benefits stop, it doesn't mean they've found you are healthy again. It means you remain eligible for cash benefits automatically for 3 years. So your period of eligibility for cash payments is extended by 3 years. If anything happens and your SGA earnings drop, your earnings drop below SGA, you're eligible for your full Title II benefit again. So let's say you made $1,600 on your Title II benefit. That was your benefit rate. And you went back to work and you started earning 500, then you earned 1,000, then you earned 1,500 and 2,000, et cetera, et cetera. When you hit that SGA level, your benefits terminated. They suspended, your benefits suspended, but you remain eligible. Anything happens after that to get your benefits turned back on again, you need to talk to your employment network, file a new work activity report, and it gets turned back on. You're not at the back of the line.
So that the question that people have, I'm going to have to wait another 2 years to have a hearing to get back, to get disability again is not accurate.
Correct. Let's do the next one. More incentives. Okay, it gets even better. Can you believe this? Who knew? So when your extended period of eligibility ends, if you're still working and you're making over SGA and you're happy, then you're happy and life is good. Maybe there's a setback. Maybe there's some new thing that came up. But if there's a new thing that came up, if it has affected your ability to earn SGA level earnings, you can get back on cash benefits again. And you're not having to wait for a whole new cycle and a whole new application. It's called the expedited reinstatement period. That lasts for 5 years. And it begins after the EPE period. So think of that, 8 years, right? That's a long time to have protections and a safety net underneath you. I wish I had an 8-year safety net when I started working. I don't know, maybe you did too. The good part about this is nobody knows about this until you talk to them. And then it's like you've lifted 1,000 pounds off their shoulders. Now, here's even more good news. Not only do you have this period, but when you apply for expedited reinstatement, you automatically get 6 months of your benefits. They start paying your benefits again while they're figuring out, are you still disabled or not? So, right? Who thought that would happen? Nobody, but it's true. And when they do that, that's when Social Security reevaluates their disability. All right, let's do the next one. And please feel free to jump in because I'll just
Yeah.
talk.
Well, that's fine. I had him originally was in the middle because he knows this so well. And so I will jump in here and there.
So SSI's work incentives are different. They are basically encouraging work. There's a reduction formula that applies. And anytime they're in SSI and they're working, they're going to be better off financially. And we'll let you read this on your own. Same with impairment related work expenses. Those are expenses that are subtracted from Title 16 benefits. These are the detail of those exemptions. Wow, saving you $20. Wow, that's big, right? $65. Wow. If you're a student, it's awesome. It can give you an additional $8,230 of benefits. Medicaid can also continue even after you return to work.
And I think that's key because I hear that over and over again. If
Mhm.
I return to work and I get a part-time job or I get a hourly job and I don't have insurance and I have this disability and I need medical care, I'm not gonna have insurance. And the jobs that I'm eligible for aren't gonna pay for insurance. They just don't realize this benefit.
Indeed. And basically, there's all kinds of work incentives out there for folks. They need to be aware of them. And you can help with that. Okay, Michelle.
Okay. Just seeing where we are, I'm sorry. Many of us use the Rappel method. Others may use other methods, but at least in Rappel, that rehab plan part of Rappel does cover, and I'll just read it real quick, determine the rehab plan based on the client's vocational and functional limitations, vocational strengths, emotional functioning, cognitive capabilities. This may include testing, counseling, training, and so forth, and placement and other needs for increasing employment potential. Also considers reasonable accommodation. So it's part of our method. And again, I don't see at least many reports considering those resources that are out there in evaluating the rehab plan. Next slide. Under placeability, that's where I really see it come in as you're making that evaluation of how placeable that person is. What are the resources in your local area? And again, I don't just consider these public benefits. I'd also consider what would it cost in the open market to give the court some leeway to see if you know, it may not necessarily be free services, but here's what it would cost and let them make a decision as they're trying to settle the case or as it goes to court. Considerations for training in a forensic file. Individuals may not make the best decisions without a vocational rehab evaluation plan, thus not using their settlement wisely. I've had several cases, and this isn't a typical, well, this is a settlement case. I had an individual, when I first went into private rehab on my own, in my own practice, I still did a little bit of medical case management. I had a guy come to me, he had a knee injury. He had 3 ACL repairs, unsuccessful. The telephonic case manager that had been on it wasn't very familiar with the doctors in our area. The doctors that were used were new. I had never heard of any of them. So we got him to a very reputable doctor at Vanderbilt. When they did an osteotomy, they did an ACL reconstruction, he did fantastic. But all along advising him, my role wasn't voc rehab, but I just can't help myself. I kept telling him, let's think about retraining. You know, you need to start thinking, here's some info on voc rehab, because I don't think you're going to need to stand on your knee. But he ended up with some decent standing restrictions, but he still needed to be light. He'd been a stock clerk. So he left that grocery store and went to another grocery store doing stocking. Later, the case reopens. He's aggravated this knee. I go and I meet with them. And I said, why did you not go get your training? Why did you not, why did you go to a standing job? We had all those bills. I'm a stock clerk. My wife is a CNA. We don't make a lot of money. And even though we were getting 60% of our income for TTD, it was a hardship for us. And so much of our settlement went to that. So having some good suggestions in your report is good because they often will not use that settlement wisely. And in his case, it was just a necessity. He had to pay his bills and he couldn't take the time off to go retrain. He had some sedentary interest, but he just couldn't do it.
And his vocational identity is I am a stock clerk. I'm returning to work.
Well, he was fine with changing. He had an idea of what he wanted to do. He just couldn't take the time off to do it. You've got the.
Sure.
Could the forensic report or the plan include some sort of financial planning so a claimant does not use up all their settlement? And it goes towards training, for example.
I do that. If I'm doing a wage earning capacity report, in that I'm going to have a section on vocational potential and I'll include retraining and what it would cost. I'm usually going to give 3 examples. And that way, because I don't get to do the ongoing work with that individual and I don't know, but it gives some options and some price ranges, and then the attorneys can use that as part of the settlement. I like having the suggestions in there and the resources in there, because after the case is over, the person who doesn't know a thing about voc rehab may have never had any training since high school, may not have graduated high school, is going to have kind of not a full rehab plan, but at least access to some resources and some suggestions. Okay. And can we go back one just a second? I think that's where I said, I put some recommendations in there. They may have setbacks and medical problems that deter training, but the employment network can help them with the support to do job placement. Also, people have ideas, or I have found, that aren't reasonable with their restrictions. So they know they can't go back and be the stock clerk, but then plan B also isn't a good option for them. So it's nice for them to get to a counselor who can work with them and try to help them make a reasonable goal and understand why maybe something they're really interested in doing may not be the best idea for them. And the whole thing that I said, it's a continual theme with my cases. Social Security has deemed me disabled. I am disabled. And being able to explain with them that this may not be the case. It may just be someone that has a disability for 12 months and is expected to recover. And even they may be just getting a temporary period of disability. Reminding them about continuing disability reviews may sometime deem them not disabled. So you might be disabled today, make some planning, because this is not definite that you will always have Social Security disability. Okay, next one. Well, the goal of Ticket to Work is to keep individuals out of poverty. We've already seen what that looks like as far as the payments go. Vocational services are free to beneficiaries. Our expert reports can reflect options for future employment. So I think we've pretty well covered this. Effective and accessible alternative to private vocational services or state voc rehab would be the Ticket to Work. The services that are provided do not have a medical review later, and beneficiaries are voluntarily active, often after realizing that settlement can be exhausted quickly. Just like John said, he may get a call once they've exhausted their settlement money.
It happens, definitely. And also, if you're doing work for the plaintiff side, expect your defense to talk about these things. If they're not already doing it, it certainly will be happening, because that's going to go not only to the motivation of the claimant, the injured party, but also to your own credibility in terms of, did you even tell them that these were options, things of that nature. So,
and I do see injured individuals ask that in depositions and at trial. Have you done anything to mitigate your damages? Have you tried? Have you, and again, my attorney in small town Tennessee, well, isn't there the want to factor? It makes it look like they haven't even tried. And it's powerful when someone does try and not trying to make a case one way or another, but fails, because then they show, well, here's what I tried to attempt to do. Here's the problems I had doing it. It makes that more real, and maybe they really are disabled. So they've given every effort to attempt to return to work.
So these we can go through fairly quickly. We kind of touched on it earlier. When you have the scenario of they're currently getting Title II benefits, their trial work level is 980. When they start earning, they may have several months they're not making 980. That's not using a trial work month. 980 and higher, it is trial work level. When they've completed any kind of work, let's say they start working, they don't have just $1,600 in a cash benefit anymore. Let's say they get to the point where they're earning $3,000 a month by the end of their trial work period. Their income is $4,600. That's a whole lot more incentive than your income is $1,600, isn't it? So these incentives are real, and people are thinking, like all of us, well, what do I have the budget for? Do I have the budget to fix the car that's broken again? Or do I have the budget to actually replace the car? Do I have the budget to take my family to dinner? or do I have the budget to make hamburgers at home? It's helping them understand that they have some input, they have power, just like they did before disability, right? We're about independence. We're about people being able to do whatever they can do. These are some options for helping move forward with that.
And I think those of us that work in forensics, because our goal is not to rehabilitate the person, forget that at the core of our being is helping that person meet their greatest potential. So we're not advising them, but at least letting them know that these work, I will reference, there's a whole 60-page book of work incentives. So you can go online and look at that if you want to. I'm still not doing a rehabilitation plan. I'm going to note it in my report, but that there are some options for them.
We've talked about extended eligibility. This is just a reminder summary. We can go to the next one. Expedited reinstatement we've covered. We can move on to the next one. We wanted to make sure you heard us the first time. So.
Repetition's helpful. It is for me.
Now, I will say this about the CDR exemption. They don't think it's real. They think, well, I'm hurting. Can't they see that? I'm hurting. What Social Security sees is whatever the medical reports say. That's what they see. And so the CDR protection is a huge, huge thing. If they're not in Ticket to Work, here's a good example. They're not in Ticket to Work, but yeah, they're motivated to do something, right? They're not in Ticket to Work. They start having earnings. Their earnings start, if they're Title 16, right? The countable earnings begin right away. Their Title II, it starts later. But then they're working, they're very proud. Oh, this is awesome. You know, I'm back at work. I'm doing something, I'm trying. CDR. They saw income, CDR. You have earnings over SGA, CDR. You're no longer disabled. Why? Because you had a CDR and the CDR said, you're working, you seem to be healthy. You tell the doctors how you're doing better. So in Ticket to Work, they don't have to worry about this. They don't have to worry about any threat to their benefits. It automatically comes back. The CDR elements is a huge thing. And, you know, the last thing you want to do is receive a letter saying, congratulations, Mr. Smith. We see that you returned to work and have been doing so well. It appears you returned to work March 30th, 2021. We've been paying you all this money. And we think your eligibility stopped on this date. We would like our overpayment back. We take Visa, MasterCard, and American Express. Here's the 16-digit boxes. Oh, those letters come, folks. Those letters come. So you really want to make sure that folks are aware that this protection is huge. Go to the next one. Independence. We've been talking about this. Anybody like to be independent in here? Anybody? Anybody? Okay. Your clients want to be independent too. Does anyone here want to be told how much you can earn? No, it's up to you. So this is what we want to instill in clients as well. Next one. And of course, returning to work protects the individual from decreases following the settlements. They have financial stability. They have stability that they can control. It's not external, it's to them. And any questions?
Let's get back over.
One of those dumb questions you asked. I just want to make sure first that I understand. So you're getting referrals in Ticket to Work for individuals who have been approved for Social Security disability. And your role is to help them return to work after they've been deemed disabled by Social Security disability, correct?
Yes.
Okay. My question is, do you have any idea what percentage of people that you're working with actually get off of Social Security disability and return to work? Because at one time I saw statistics that said it was like less than 0.5%. I just wondered if you had any info.
Well, think of that average. That average didn't study separately how many folks were returning to work based on Ticket to Work services or not. Right now.
And attorneys will throw that up at you. Well, you have this Ticket to Work in here, da, 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 da. And isn't it true, Ms. Weiss, only, 0.5% go back to work? I've had that question. So
Presently, 22% of my people are back working now. Oh, and by the way, you get paid when folks go back to work and Ticket to Work. That's the other thing. But it's their motivation. You know, this is often the first time they've heard since ever, maybe, that you can do what you want to do. What do you want to do? What do you want to do? And we're here to help you map that out so that you understand no one's imposing anything on you. You participate or not, understand if you don't participate, what's going to happen. But if you do participate, think your whole world can change. So it's an important
And
consideration.
I've also found in forensic evals, but think of my angry client that I mentioned. We probably spent an hour just calming him down to really be able to have a good eval. And I'm on Social Security disability and I can't work and da, 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 da. By the end, and it was, you're right, this is your life. You know, we're dealing with your life. It's a serious matter and I want to hear your story. And I want to know what's going on with you. By the end, the individual was saying, you know, I might be interested in retraining. I might be interested in doing something. Now, I'm not trying to convince him, but I think it was more so that he was heard and someone had taken the time. Maria's in here and we both do very thorough evaluations and we spend a lot of time with somebody. And the reason we do that is to get that full picture and do vocational testing and everything that we need. And in doing that, though, that person doesn't feel like you're rushing them through an eval and they're not being heard and that you're getting that full information. And I keep going back to Tim Field the other day in 101 and 201. We should be about doing excellent work. And we shouldn't forget that foundation of why we got into this. But okay.
How do you get involved in providing those services, the Ticket to Work?
If we got
Excellent
just a couple
question.
minutes,
Thank
super.
you very much. So Ticket to Work employment network applications are available at chooseworkttw.net. And also our contact information is here. Feel free to send me an email or visit my website. My email address, actually, I thought I put it there, didn't I? No. Email-
And the IARP directory has it in it if it's not there.
chooseworkttw.net. And also you can email me directly, john.yent